Okay, hey everybody, this is Daniel from BarWinners. I've got my student Mia with me, and we are going to go over how to take an MBE, as well as go through at least one question to sort of enact the strategies that we're going to go over right now. MBE questions. What are the instructions in terms of how to select an answer? Does it say choose the best answer or choose the right answer?
Probably the best answer.
The best answer. Why? Rhetorical question. I'll answer that myself. MBE are designed to be difficult questions. This is testing not only your knowledge of the law, but also your ability to critically think and analyze. The reason the instructions say choose the best answer is because there's not always a correct answer per se. If you took an MBE fact pattern to 10 different juries in 10 different districts, you might come up with 10 different interpretations of the law, of the facts, and 10 different verdicts, so to speak, or awards of damages or what have you. So the MBE is about choosing the best answer, which is why process of elimination is so key in how you take these questions. Speaking of process of elimination, the way we're going to go through these MBE questions really highlights the process elimination skills and strategies, as well as knowing the law. Mia, give me a quick breakdown, if you will, of how you were taught to take an MBE question prior to BarWinners.
So during law school, we were taught to read the call of the question, then read the facts, and then read all of the answer choices, and then go back and read the call and answer choices if necessary.
Okay, so call the question first, facts, answer choices, and then kind of repeat that pattern. Were you asked to, in the fact pattern, sort of come up with your own answer as you're reading the facts and try and formulate an answer and match that to the answer choices, something along those lines?
I think everybody always says that's the goal, but I don't think I always did that. But I would try to at least form what I thought would be a close to the correct answer or correct type of law.
Common strategy. Nothing wrong with it per se. I think it's just more difficult than the strategy we're going to go over. In order to formulate your own answer, you have to know the law so well and be able to really analyze those facts spot on as you're reading through, which I just think is incredibly difficult, especially because the MBE is known to test not necessarily broad law all the time, but more the nuances and exceptions, defenses. We've all seen that, especially in real property. They get down to the nitty gritty in MBE. So formulating your own best answer, I think, is just a more difficult task than what we're going to do. So, and we'll do some examples later. The basic gist of the BarWinner strategy for MBE is read the call of the question first, try to identify the subject if you can, torts, for example. Typically, I have students read literally one line up. If your call to question is here, read one line up. You usually get some more information in terms of exactly what the call is leading to in terms, or for example, if you're in a constitutional law question and the call to question says, is this ordinance constitutional? Typically, if you read a line up, guess what you're going to get? You'll get the ordinance or the statute.
Yeah.
So, BarWinner strategy first, read the call of the question, identify what you can, and then typically read a line up. Those are the first two steps, see what information you get. Third step, this is where we deviate a little bit. As opposed to going to the fact pattern, we're going to read each answer choice one by one and see what knowledge we can accumulate by reading the answer choices. Any idea why we would read the answer choices before the fact pattern?
Maybe not to get confused with the facts.
Sure. So unlike the essay, where when you read an essay for the California bar exam, every fact is relevant, every fact is important. There's rarely will you ever have a fact that is benign, so to speak, or not usable in one of your arguments. MBE
Okay.
fact patterns, completely different, right? Red herrings, sometimes they're facts that had nothing to do with the call to question or the correct answer choice. So we're reading these answer choices first because we are at our most unbiased, lucid, clear-headed before reading the fact pattern. So when we read these answer choices, we're basically looking at law and just what might they be testing here? Are they testing IIED and, you know, the extreme and outrageous element and causation? Are they testing intent? Are they testing severe emotional distress? What exactly are they testing? And you can find that out from those 4 answer choices. And after having read those, you will have a much more focused read of the fact pattern and be able to easier or more easily discard those facts that aren't necessarily relevant to the answer choice. Fair enough?
Yep.
So we'll get a critical insight into what's going on in the fact pattern. And the second part of reading the answer choices first is, again, we're at our clearest, our most lucid at this point. If we know the issue, we probably know what law might be tested, and we can easier identify maybe misstatements of law or complete misstatements of law, maybe partial or complete misstatements of law. So with that basic groundwork and step-by-step process, let's go ahead and go into question number 1 here. And we will utilize the step-by-step process I just outlined. So if you don't mind reading the call to question for question 1.
Sure. It says, if the widower sues the developer for damages for emotional distress, will she prevail?
What subject/issue do you think we're dealing with here in this question?
I think it's going to be torts and IIED because it brings up emotional distress. And we're looking at what could create damages down the line. So we're looking for a prima facie case.
Fair enough. So we got torts, probably IID and ID, something in that range. Let's go ahead. That's the first step. Read the call to question. Let's go ahead and read a line up and just see if this helps us at all. So go ahead and read literally the last line of the second paragraph.
Sure. The widow had been badly frightened by the developer's threat and was outraged when she learned that the developer had lied to her.
Not a ton of information there. That's basically the end of the fact pattern. So we did read a line up, read the second step. Didn't necessarily help us out a bunch on this question. It does on others, but that just goes to show you process elimination will work in various ways per question. Sometimes it'll help you in the call to question phase. Sometimes it'll help you reading a line up. Sometimes it'll help you in the answer choices. So these are all strategies we use. We're not sure necessarily what information we're going to gain, but we'll go through this process for each question. And throughout the 200 that you take, you will gain insight more often than not, and that's going to help your process elimination. So not a ton of information at the end. We got a threat, some outrage, maybe a lie, something like that. And again, call the question, if the widower sues the developer for damages for emotional distress, will she prevail? So if we're in IIED, what are the elements we're working with? Let's go ahead and write those down so we can get a little memorization
So
tactic here as
IIED,
well.
you have to have an act, a intent, and causation. So an act by D, causing extreme and outrageous conduct.
So intentional act, that's their first element. So go ahead and write 1, intent. Second element, extreme and outrageous conduct. So that's 2. 3, causation. And 4, what's the critical element here at the end?
Damages?
Keywords. Not damages, but that's a good
Intent.
that you said that because that's one of the red herrings. Severe emotional distress, right? Those 3 buzzwords specifically. If you come in and you don't know the law as well, a lot of people do think damages is the 4th element because it's basically the 4th element of every other tort known to man. Not IAD, specifically severe emotional distress. But this goes to show how well or the grasp you need of the law in order to answer these questions correctly. Because if you do have a mental lapse for a second and think the fourth element is damages, it's going to cause you some trouble on this question.
Got it.
Okay, so we've written down our 4 elements. We've read the call to question. First step. Second step, we read the line up. Third step, let's go ahead and go through each answer choice one by one and have a brief discussion. Go ahead and read A.
Yes, because the developer's action was extreme and outrageous.
Basically, what you're asking yourself at this point is one question. Is there anything in here that misstates the law? Is there any law wrong?
Well, I see extreme and outrageous, and those are 2 of our trigger words for IID.
That's the second element, right? Properly phrased.
Yeah, so I would probably keep that option around because it actually uses the language of the rule.
I agree. You have to be spot on with the law in any phase of the bar exam, particularly the MBE. Extreme and outrageous, those are definitely 2 buzzwords. That is the second element of IID. So nothing is incorrect. There's no misstatement of the law here. So that's the first thing we're looking at. The second is gaining information, right? So we know IID is probably at issue in this fact pattern. And now we know that extreme and outrageous is going to have to be analyzed as well because we see it in one of the answer choices. Does that make sense?
Yes, it does.
Okay, so go ahead and read B.
B is yes, because the widow was frightened and outraged.
Anything stand out in this answer choice as correct, incorrect, none of the above?
So 2 things. One, the word outrage is similar to outrageous, but I think that would be more of a red herring because the word frightened is a really specific emotion. So I would think that that word would connect back to that last sentence in the fact pattern. So it does kind of use a little bit of what the facts are stating. So that would be a maybe question, a maybe answer.
So there's a couple of things going on here, right? So because the widow was frightened and outraged is really discussing the widow's reaction, which is the 4th element, right? And is the 4th element that you need to be frightened and outraged?
No.
What's the 4th element?
Extreme emotional distress. Severe
emotional distress, right? So not quite the standard we're looking for one. And 2, if they're looking at the second element, what's the second element of IID? Is it frightened and outraged?
No.
It's extreme and outrageous, right?
Correct.
So you can see this is kind of conflating the second and 4th element with the wrong words. So I'm not going to go ahead and say B is 100% wrong, but what we can do, part of the BarWinner's method, is if we see an answer choice A, B, C, or D through the first read through, and we are, I'll go conservative here and say we are 80 to 85% sure that this is a misstatement of law or just not correct law, we can put 1 slash through it. So you can literally from bottom left to top right, put 1 slash through B if you are in that range of 80 to 85% sure that this is just a misstatement of law. If you're not that comfortable, no problem. I would still give yourself some kind of indicator, maybe circle frightened with a question mark or something along those lines to let you know, something didn't quite sit well with me with this answer choice. Okay?
Okay.
Let's read C.
No, because the widow did not suffer emotional distress that was severe. So I see a lot of our buzzwords here. Suffer emotional distress and also severe, like we talked about in A. So I would definitely not put a slash through that because that use a lot of different buzzwords.
Yeah, looks like at least a correct statement of law, right? In terms of the severe emotional
Yeah.
distress. Whether the widow suffered it, we don't know yet because we haven't read the facts. But it looks like we have correct law. And again, we've gathered some insight into what we need to be looking at in the fact pattern, right? We're getting some focused look inside in terms of when we read the fact pattern, we know the severe emotional distress element is going to be at play here, and we're going to be more readily able to diagnose and analyze whether that distress element was met.
Mm-hmm.
Okay, let's read D.
D, no, because it was not the developer's purpose to cause emotional distress.
Any thoughts regarding answer
Well, this
choice
time
D?
I like the idea of the fact that it says cause, because
Okay.
that leads me to think of like a causation, that there was like a direct link. And again, with the trigger words of emotional distress. However, I don't feel like this might, I mean, this talks about one element.
It kind of talks about a few elements, right? It's got the causation, it's got emotional distress, but what word is missing from that fourth element?
Severe.
Severe, right? Does that mean it's wrong necessarily, that D is wrong because severe is missing? No, but the MBE is pretty good about their legal knowledge and writing correct elements and law and rule statements. So it's a little off. What other word is a little off here? Another element.
Emotional distress.
How about purpose?
Okay.
What does purpose mean legally? What word is typically
Intent.
used? Okay, why don't they just say intent here?
They don't probably want to give it away.
Yeah, I have no idea, to be honest with you, but I think it's to sort of take the student down the wrong path. The MBE are not designed to be user friendly, right? You have to think critically, and again, you have to know the law. The element is intent, it's not purpose, and you need the intent to commit the act as opposed to the intent to cause the emotional distress. So there's a couple of things here again that legally just don't sit right. I don't know if this is enough to slash answer choice D. And again, let me emphasize, just because you slash an answer choice at the beginning does not mean that this answer choice is completely off the table. And we'll kind of go over that in the second read through. It just means something just didn't sit right and you're at that 80 to 85% level, that there's some incorrect law going on, okay? So I'll leave it up to you and all those viewing whether you want to slash D or not, or even B, but I would make a couple question marks or, you know, circle some of those odd words like frightened and purpose in answer choices B and D to alert yourself on the second read through that something's not sitting well here, okay?
Okay, so what I think I understand is that we're putting like our goal is to eventually get 2 slashes through
Not
each one of
necessarily.
these.
Not necessarily. So
Right now we have a slash through B and a slash through D because we know that there is some incorrect law. And so those aren't going to be as correct right now.
Potentially, right? So we don't necessarily want to cross out every single answer choice. This is a process of elimination. So with the MBE, you kind of want to reverse engineer your way to the correct answer, right? Or excuse me, I just messed up right there, right? The best answer, not the correct answer.
Yeah.
So what we're looking to do is erase those answer choices that aren't the best, right? We're kind of reverse engineering and taking away answer choices that don't look good. And oftentimes you'll be left with the best answer choice.
Gotcha. Cool.
Okay.
So are we ready to read the facts?
Let's read the facts. We have potentially a slash through B and or D, depending on your individual comfort level, but at least we've noted, again, frightened in B, a little weird, purpose, no severe in D. So that's what we've highlighted so far. A and C look like plausible answers. Okay, go ahead and read the facts.
A real estate developer was trying to purchase land on which he intended to build a large commercial development. An elderly widow had rejected all of the developer's offers to buy her ancestral home, when she had lived all her life and which was located in the middle of the developer's planned development. Finally, the developer offered her $250,000. He told her that if she rejected it, state law authorized him to have her property condemned. She subsequently parked a bulldozer in front of her house. Oh, he did, excuse me. The widow then consulted her nephew, a law student, who researched the question and advised her that the developer had no power of condemnation under state law. The widow had been badly frightened and the developer's threat and was outraged when she learned that the developer had lied to her.
Let's go ahead and read the call to question again.
If the widow sues the developer for damages for emotional distress, will she prevail?
So again, reading the answer choices prior, we got a more focused read into what we were looking at in the fact pattern, right? You had the extreme and outrageous element a couple times, which is the second. And then the third and fourth answer choices, C and D, both discussed pretty much the fourth element of severe emotional distress, right? So those were the two elements that seemed to be most in play in reading this fact pattern. And you can see by reading the answer choices, I think right away helps you, because as you read the first line of the fact pattern, we talk about a real estate developer, you might be thinking property at that point. Even had you read the call of the question, without reading those answer choices to affirm that this is about IIAD, you might read real estate and be thinking property. And even thinking that for a few seconds is going to take away from your critical thinking skills and being able to analyze properly about what the real issue is here: intentional infliction of emotional distress. So let's read through these answer choices again. So again, reviewing the steps very briefly: read the call of the question, read one line up to see if you can get some extra information. In this case, we didn't really get much that helped us. Read answer choices A, B, C, and D with two purposes. One, look for incorrect law. Sometimes there is incorrect law, sometimes there's not. A majority of the questions, I think, will have probably some kind of a misstatement in one of those four answer choices, but some don't. For those that don't have any misstatement of law, you're still gaining critical information about what this fact pattern is going to be telling you, okay? So after you read the answer choices, you read the fact pattern, read the call again, and now we're in the second go around of reading the answer choices. So go ahead and read A.
Yes, because the developer's action was extreme and outrageous.
What do you think about this?
Well, we know that I think it's really good, actually. It's mostly right. I don't see much wrong with it. The developer, what he did was he threatened her by saying her property was going to get condemned and then put a bulldozer in front of her house. So I think that would be pretty extreme and outrageous.
Right. You've got good arguments on both sides, right? You can argue the bulldozer and the condemnation is extreme and outrageous. I guarantee you somebody could argue that it does not meet that threshold, right? A little subjective there, but it's a plausible answer. I agree. Yeah. So we're going to keep A?
Yeah.
Okay, so let's read B, and before, let me preface with, if you did /B on the first go around, you're basically asking yourself at this point, did anything happen in this fact pattern to sort of bring B back to life or make B a more plausible answer choice, right? Because why did we /B initially?
Because it didn't use the correct terms of art. You used the word frightened and outraged instead of severely extreme and outrageous, talking about the conduct.
Yeah, extreme and outrageous. Or if they were talking about what the widow suffered, it would have been the severe emotional distress. So kind of not only used the wrong terminology, but conflated two elements as well. So did anything happen in this answer choice, or excuse me, in this fact pattern to make B a more plausible answer?
No, not
I agree.
really.
Let's go ahead and read it anyway, and then we'll re-ask that question. Go ahead and read B again.
Okay, because the widow was frightened and outraged. Well, we already know that because the last sentence states the widow had been badly frightened, and so there is just the reiteration of those same terms. So I don't
Exactly.
think that would be the correct answer, because it already answers it in the fact
And that's
itself.
the red herring, right? These are not the elements. It's either the conduct is extreme and outrageous, or the widow suffered severe emotional distress. Those would
Okay.
be the two options there. And B, again, conflates and combines both. And it's the red herring because that last sentence says the widow had been had been badly frightened and was outraged. So again, if you don't know
Yeah.
the law, you're going to read that last sentence and probably go toward B because it fits what you read in the facts. But B is not the correct
Okay.
answer. Okay? So let's read C.
Okay. No, because the widow did not suffer emotional distress that was severe.
What do we think about this answer choice after reading the facts?
Well, just to piece it apart, it's saying that the woman did not suffer any emotional distress. And
Does it say
clearly she
any,
did.
or
Well,
does
it
it
says
say,
that it was severe,
okay?
but if I were to just say, did she suffer any emotional distress? Yeah, she absolutely did. So that would kind of turn me off for C. But suffering the distress that was severe, mm, there's that other buzzword.
So it's got the terms of art, and again, there's a plausible argument to be made that the widow did not suffer some emotional distress that was severe, and you could probably make an argument that said she did suffer severe emotional distress. I think an argument could be made either way, and in that instance, do we have enough to eliminate this answer choice?
I think so. I think that it is not the best. I think so far the best is A.
So C does not necessarily need to be the best at this point, but can we, if we're looking at subjective arguments at this point, in terms of you can make an argument either way for C, that the distress was severe or that it wasn't, that would not be enough to eliminate an answer choice at this point.
Okay,
Okay, so
sounds
we
good.
can kind of debate between A and C as we go forward. But if you're getting down to subjective arguments in terms of, oh yeah, it was extreme and outrageous conduct, or no, there's no way she suffered emotional distress, that has to do more with your reasoning and subjectivity as opposed to a concrete legal answer, which I'll kind of explain a little bit more as we go forward. So we're going to leave C for now. We're going to leave A. B was slashed out. If you really didn't like B, you could have put one more slash through it to give it an X. Your
Okay.
choice. Let's read D.
No, because it was not the developer's purpose to cause emotional distress. So back to you talking about purpose versus the word intent. So if I were to switch that term, it would say no, because it was not the developer's intent to cause emotional distress. Honestly, I think that that is completely incorrect, because obviously he did want to cause her emotional distress in some way, shape, or form.
So we'll get back. So let's look at the rule statement first. Purpose instead of intent. It should be intent, right? And not to cause
Mm-hmm.
emotional distress, but severe emotional distress. So that's the legal part. That's the rule statement part of answer choice D. And that's not
Mm-hmm.
correct. Slightly off, but that's all you need. Okay. Now, the
Mm-hmm.
second part you were talking about was more of the subjectivity, the argument, the part that you would kind of, argue back and forth on an essay, perhaps. If this were an essay, you would say, well, the developer could argue this and the widower could argue this. And then you would conclude, and both your arguments would probably be sound. So that's not always going to lead us to the right answer. Actually, a majority of the time, the subjectivity of the arguments is another red herring. And I'll explain that between A and C. So we'll
Okay.
go ahead and put a slash through D because of the incorrect law, and we'll look at A and C. One says yes, one says no. First, A, yes, because the developer's action was extreme and outrageous. C, the widow did not suffer emotional distress that was severe. Can you make a plausible argument both ways for A and C, that
Yeah.
that both the action was extreme and outrageous, and can you make a plausible argument that the action was not extreme and outrageous?
Yes, you could make
I
both
agree.
arguments.
Right. And I don't think those arguments would be extreme and outrageous. Horrible pun, but I think you can make two plausible arguments for A. Okay. C,
Okay.
could you make an argument that the widow did suffer severe emotional distress, and probably a plausible argument that she did not?
I would probably say that yes to your first question and no to the latter,
Okay.
because I think no matter what, just by reading that last sentence, it clearly states that she was frightened, and she felt threatened.
So are you saying
Therefore,
that
I would,
meets the threshold of severe or does not meet?
yes, I think it does meet the threshold of severe.
Okay. So I think you can make a plausible argument for both. I think you can say she was frightened and outraged, and that does not meet severe emotional distress, right? We could say severe emotional distress is something like post-traumatic stress disorder for war veterans or something along those lines, right? I think that's a
Okay.
higher threshold. But we could also say, and if you were her attorney, that she did suffer severe emotional distress because she's elderly and maybe, she has high blood pressure or some kind of condition or something along those lines where this threat and the bulldozer did cause her severe emotional distress. The point is, you can argue both. Okay. So
Mm-hmm.
how, if we can say we have a plausible argument on both sides for both of these answer choices, how do we distinguish the two? How do we come to the best answer?
I would use the answer that integrates both the law and facts from the question.
Okay, so we're getting back to the subjectivity part of this, but let's look at the actual wording and technical part of this question. Okay, if the widower sues the developer for damages for emotional distress, will she prevail? So that's it. Will she win? One says yes, one says no, right? A says yes, C says no. With me so far?
Yep.
How many elements are there to IIAD?
4.
If you are in court, how many of those, and you're the plaintiff, how many of those elements, in order to prevail out of the 4, do you need to establish?
All 4.
If you are the defendant, how many of those elements of the 4, in order to prevail, do you need to sort of not establish?
1.
1, right? So in terms of choosing the best answer in this instance, we're going to go with C, because A is about 25% correct. If the widower sues for damages for emotional distress, will she prevail? A says yes, because the developer's action was extreme and outrageous. That answer choice is only assessing one element. And again, how many elements do you need to establish in order to
4.
prevail? 4. That's just one. A is 1 out of 4. If it had said intent, causation, severe emotional distress, maybe we have a better answer. But again, A has 1 out of 4. C is more definitive, because in order to not prevail, in order for the widower to not prevail, all you need to do is establish that one of the elements is not met. So in C, which element would not be met according to that answer choice?
Severe.
Right, the severe emotional distress aspect. So
Yeah.
you see how C is a more complete answer than A.
Yes.
In order to prevail, you need all 4. So A is kind of partially correct. I say 25% because it has 1 out of the 4 elements. But C is more, it's more correct. It's a better answer, because if you don't establish one of the elements, you automatically lose. You're done.
Gotcha. Cool.
Okay.
Awesome. Thank you for going
All
through that
right.
with me.
Absolutely. So this has been Daniel with BarWinners. We went through one painstakingly long MBE question, but hopefully this has helped you and given you a strategy to attack these questions going forward. Remember, the most crucial aspect, read those answer choices first. And you want to be looking for 2 things. Identify any incorrect law. If all the laws is fine, leave those answer choices. But at the same time, the second portion of reading the answer choices first is identify what might this fact pattern be testing me on. And in this instance, we got extreme and outrageous and severe emotional distress as the main elements that we were looking at as we read the fact pattern. So keep those tactics in mind, and I will see you next time.
Awesome. Thank you.
Got it. Stop recording.